Go ahead.
Thank you, Your Honor. Ladies and gentlemen, I'm going to try to make this as brief as possible. You've been very attentive and spent a lot of time listening to myself and counsel for the defense arguing this case. But there are a number of points that I do need to talk about that the defense mentioned in their closing argument. They wanted to make a big deal about the drug trafficking by Mr. Holmes. They wanted him to tell you all these details about everything under the sun relating to it. That's not what's important about it. What's important about the drug dealing is absolutely the drug dealing was the reason why Stephanie Lowe was murdered by the defendant, because he is the one who wanted the drugs. And there is absolutely no evidence, not one shred, one piece of evidence in this case that you have heard relates to anybody else having that motive or that reason to kill her on October 10th, 2010. And you heard that law enforcement, you repeated, I think, a couple times, that law enforcement considered other suspects. But the defendant's the one who rose to the top because the defendant's the one that there's evidence of committing this crime. The defendant's the one that told Richard Hawkins, that told Andrea Wadinsky, that told Adam Smith, that told Rebecca Torgerson, that told Doug Kotlitz, and that told Jacob Stoltz that he killed her. And he's the one that you heard him in his own voice say, I killed her. It wasn't intentional, but I killed her, using his weird idea of what intent means. As to the defendant having the opportunity to clean up, clearly you heard from Andrea Wadinsky she didn't see him until later in the afternoon. And the defendant was off of his phone from about 2:17 to 5:23, smack in the middle of the time that the situation at Stephanie Lowe's apartment changes. Changes from the door being locked at 11:30 to the door being unlocked around 5 p.m. 2 times when Mark Prosser goes there that day. The first time by himself, the second time with Alyssa Michelle. And I think it's important, and counsel says, well, he didn't really admit to Yvonne that he killed her. Well, I think the difference he did. But remember what he starts out that whole section with is, how do I say this without incriminating myself? Now, he's not worried about incriminating himself about hiding the body because he's already led law enforcement to the location of the body. He's already clearly incriminated himself about that. He's only worried is, how can I tell you I killed her without incriminating myself? Well, it's by trying to claim I didn't do it intentionally. Counsel talks a lot about the comment of Andrea Wadinsky that said, I don't think he's smart enough, excuse me, I don't think he's smart enough to think about whether or not he's got DNA under his fingernails. Well, first off, how much smarts does that take? Anybody who watches any TV at all knows that's the first thing that people look at. But let's look at his smarts about what he does and what we know he does in this case. All right? Counsel says, in his closing, after saying he's not very smart, he's not smart enough to think of this, says, the argument that he makes in his letter to me is exactly the same argument that counsel, an experienced lawyer, makes. If he's smart enough to make the same argument that his attorney does, he's probably smart enough to know that if he's scratched, his DNA may be underneath his fingernails. And he's smart enough to cook up a scheme with Josh Howard when he knows the evidence doesn't look good, when he knows the evidence is going to show that he's guilty beyond a reasonable doubt, because, not only because he knows the evidence is going to show that, but he knows he is guilty, to cook up a scheme with Josh Howard, the person the defendant sought out. to have Josh Howard create an appeal issue for him. He's smart enough to do those things. I think he's smart enough to figure out that getting scratched is going to leave evidence. I'm not going to go through every one of them again, but the defense in their closing wants to pick and choose what every one of these witnesses saying is true and not true. Because we know what they described about the burial is true. We know that's true. We know that's true because of the physical facts. And we know the defendant is involved in it because the defendant is the one that told them about it, or we were there when it happened. And we know from the investigation and from what happened when the defendant himself went to law enforcement to the body, that what he told them was true. Telling the truth on that. All this other stuff about why they are or are not credible really doesn't matter because we know they're telling the truth about this, so why are they making up the parts where the defendant admits to killing him? The parts where he admits to killing Stephanie Lowe. And ladies and gentlemen, I should have probably objected when counsel said it, but frankly, this comment that Rebecca Torgerson supposedly may or may not have said back in December of 2010, that comment was stricken by the judge on an objection by us. That's not evidence in this case. It's not evidence. It's something that the judge told you can't even consider. Counsel never should have mentioned it. Counsel talks about the fact that Rebecca Torgerson didn't see a shovel or flashlight or anything else in the vehicle. Well, there's no evidence that she was even looking for it. She didn't see a knife that was there and clearly was there. And frankly, the defendant didn't bring a shovel with him when he was originally going to bury the body. Maybe he figured he'd go buy another one since he had to get rid of the first one back in 2010. The state is not trying to make Andrea Wadinsky or Richard Hawkins victims in this case. There is only one true victim in this case, and that's Stephanie Lowe. There's another set of victims, and that's Stephanie Lowe's family. Andrea and Rich are not victims. They are people that were forced to be accomplices by the defendant, but they're not victims in this case. And Andrea did admit that she lied. She admitted repeatedly that she lied early on. But again, the defendant cannot get away from that one inconvenient fact. And that one inconvenient fact is that once Andrea Wadinsky started telling us what happened, and once Richard Hawkins started telling us what happened, everything they said that there was a possibility it can be corroborated was corroborated to a T. You can't have them telling the truth about that and not telling the truth about the defendant's admissions that he killed Stephanie Lowe. I want to talk a little bit about Dr. Steer and spend a little time on Dr. Steer. Dr. Steer is looking at a body that's been in the ground for 4 years. I know he said, yeah, the ground can preserve things. And it may preserve parts of the body, but we know it does not necessarily, and it doesn't preserve DNA evidence. And we know that because Benjamin Starkey, who's an expert on DNA, told you that. He said that dirt and water and snow and ice and moisture and all that stuff can get rid of DNA. We know it because Benjamin Starkey told you that, and we know it even based upon his analysis because he tested a portion of tissue that absolutely, positively, no question about it, came from the body of Stephanie Lowe. And he told you that DNA was degraded, and it did not have, he could not get a complete profile of that DNA. So if it's clearly being buried for 4 years affects the DNA enough that he can't get a profile from a tissue sample, how much is it going to degrade the small amount of DNA you're going to have from cutting somebody with your finger? And I think what's important about Dr. Steer's testimony is that Dr. Steer tells you this is a homicide. Now he tells you, I can't find evidence except for a small cut on her wrist of cuts, stabs, incisive wounds, whatever. But I do find one there. But what's important is we know there was a knife used with a lot of violence because that knife is broken. The fact that the body was there for 4 years, unfortunately, took away that evidence that Dr. Steer would be able to use. And Dr. Steer tells you that. And again, the defendant's own words to everybody he told about this is that the knife wasn't the lethal weapon. He didn't kill her with the knife. He killed her by strangling her. And Dr. Steer told you, yeah, absolutely, strangulation is certainly possible. And the one thing that really could have put us over the top on that and been able to show, I could have been able to tell absolutely this was a strangulation is the honest. Unfortunately, it's no longer there because of the defendant's choices. Don't reward him for his decision. Don't reward him for his burying Stephanie Lowe's body for 4 years and depriving her family of knowing what happened to her for 4 long years. As it related to the neck injury, I never heard Dr. Steer, and certainly your memory and your notes are what you'll rely on, but I never remember Dr. Steer saying that this discoloration on the neck was caused by some discomfort that Stephanie Lowe said she had a couple days ago. What I do remember him saying is that he didn't see blood, and so it could have been just a matter of decomposition. That's what he's seeing. He just doesn't know for sure what caused that area of discoloration. It's just an area of discoloration. And what he told you is there could have been a knife wound to the neck that he was not able to see. So Dr. Steer doesn't say that what Richard Hawkins and Rebecca Torgerson and Doug Hoplitz say about there being a knife wound to the neck. He doesn't say that couldn't have happened. He says, I can't tell you that there was, and I can't tell you there wasn't one. All we know, though, from Dr. Steer's testimony is that Stephanie Lowe is a victim of a homicide. Also argues, well, the defendant could have been at Rock's place or some other bar after he dropped off Richard Hawkins. Where did that come from? Where is it that single piece of evidence that he went to another bar? Not one single witness said he went to a bar. Not one single video surveillance camera says that he was at a bar after that. There isn't a single piece of evidence that supports that. That's pure fancy. And the argument, well, he wasn't using his phone, so that means he was at a bar as opposed to trying to find the crack cocaine he just killed Stephanie Lowe over, is also crazy because we know he uses his phone when he's in the bar because he used his phone to call Eric Mahomes' phone at 11:47 p.m. while he was still at breakaway. And no problem calling when he's at a bar. the, what I think it was Shelley Resch described as a bloody footprint. I'm not sure if it's a footprint. It may very well be a footprint, but clearly, this is Exhibit 54, been admitted. It clearly does show what could be some toes here. But again, we don't know whose footprint that was. We don't know if that could be Stephanie Lowe's footprint. Because remember, when counsel was trying to teach Richard Hawkins over where Stephanie Lowe was when she was on, when Richard Hawkins first got there. What the statement was in that report that counsel was reading was that Stephanie Lowe's feet were on the floor. And she was at the foot of the bed. That's what it said in that report that counsel read. That's what he read. Well, that's not saying that Stephanie Lowe is on the floor. It says her feet are on the floor. It's very well. Stephanie Lowe is on the floor. What's important about the incident with Matt Robinson, ladies and gentlemen, is that just like when he told the worst witnesses, he did to Stephanie Lowe and what Richard Hawkins observed in the morning hours of October 10th, the use of a knife to the neck, and then bleach, clean up after it. Counsel's argument. The defendant, he just did the body in return for money or crack cocaine. What? For somebody else. What evidence is there that supports that? Your verdict has to be, a reasonable doubt and a reasonable hypothesis has to be based on the evidence. It has to be based on evidence, not some theory that has no evidentiary support. And there is not one piece of evidence that shows that the defendant had contact from somebody else that said, go clean up Stephanie Lowe's apartment, hide her body, and you'll get some crack cocaine. There is not one piece of evidence that supports that. You didn't hear a single witness say that. You didn't hear about any phone calls that confirm that. You didn't hear a witness that said that the defendant ever said that to anybody. On the contrary, what you have is the defendant's own words that he killed Stephanie Lowe, but it just wasn't intentional. Words that you've heard from own ears. He never says in those recordings, I just hit her body because somebody else said I was going to get money and or crack cocaine. And counsel says, well, he was still calling Eric's phone at 3:47 to try and get crack cocaine. I submit to you that there is another very reasonable explanation for those calls. And it's the explanation that actually I'm sure is true. Because remember, Richard Hawkins told you that the defendant took the cell phone, broke it up, and threw it out as he's driving back from Modena. He wanted to get rid of that cell phone because he knew that cell phone could potentially show calls that he made. Eric Mahomes' phone. And at 3:47, as he's working to clean up, that phone is already unplugged. He's trying to call it to make sure he's got the right phone. He's making sure he's got Eric Mahomes' phone. And he tries dialing a couple different ways. First with a 1, then without a 1, then another time without a 1. Calls it 6 times. He because it's not ringing and he's not certain he's got the right phone. That's why he's calling the phone at that point in time, not to try and find crap, because he knows he's already pulled stuff off. And there's one other problem with the defense theory, that he went there, found her body, and ended up getting rid of her body like he claims he did. The defense counsel argues he did. And that problem is the door is locked. The door is locked. You cannot get back in. You can't get in there, period, unless he has a key. Because we know it's locked because Cassie Miller goes there about 2:30 in the morning. When she gets there, the door is locked. The defendant can't show up after bar time when he leaves this fictional bar he's supposedly at and find the scene. The door is locked. We don't know all the details of the defendant's deal with Josh Howard. We only know the ones he chose to tell Krista Jonda and her friend in that phone call. But we know that the deal on the defendant's side was, yeah, he's going to get convicted, but he already knew that because he knew all the evidence there was against him, all the evidence that you've heard over these last 2 weeks. So he knew he was going to get convicted. So having Josh Howard in the mix wasn't going to make it any more or less likely that he was going to be convicted. But what he was getting out of it was a sure appeal that could reverse his conviction. And then who knows what's going to happen another 2, 3, 4 years down the road. We've got a lot of witnesses who have a lot of issues. How many of them are still going to be available 2, 3, 4 years later? That's what he's getting out of it. We just don't know what Josh Howard is getting out of it. That's going to have Josh Howard paying the defendant some money. The defendant's getting a sure appeal where he already knew he was going to be convicted. I have 2 last points here, ladies and gentlemen, and then I'm done. First point, there is not one shred of evidence in this case that anyone but the defendant killed Stephanie Lowe. As you heard, law enforcement investigated and looked at a lot of suspects. And all of the evidence in this case points to one person only. That defendant. That defendant is the one who killed Stephanie Lowe. Use your reason, use your common sense. The defendant is hiding the body of Stephanie Lowe to try and keep there be evidence in the commission of a crime. And who is going to try and prevent there from being evidence that they commit the crime except the person who actually committed that crime? The only person that there's any evidence that committed this crime, ladies and gentlemen, when you consider all the evidence in this case, that evidence shows that on the reason that was guilty. That's true. Later, 6.5 years.
Great citizens to render a just and true verdict. You are to decide only whether the defendant is guilty or not guilty of the offenses charged. Any consequences of your verdict are matters for this court alone to decide and must not affect your deliberations. The following forms of verdict will be submitted to you concerning the charges against Mr. Torgerson. Verdict 1 reads, we, the jury, as in for our verdict, find the defendant Kristopher Torgerson. There's a box for not guilty and a box for guilty of first-degree intentional homicide on or about October 10, 2010, as charged in the information. There's a line for to be dated and signed by the foreperson. Count 2 is, we, the jury, as in for our verdict, find the defendant Kristopher Torgerson either not guilty or guilty of attempted robbery on or about October 10, 2010, as charged in the information. Again, to be signed and dated by the foreperson. Lastly, count 3, we, the jury, as before our verdict, find the defendant Kristopher Torgerson either not guilty or guilty of hiding a corpse on or about October 10, 2010, as charged in the information. Again, signed and dated by the foreperson. It is for you to determine whether the defendant is guilty or not guilty of each of the offenses charged. You must make a finding as to each count of the information. Each count charges a separate crime, and you must consider each one separately. Your verdict for the crime charged in one count must not affect your verdict on any other count. This is a criminal case, not a civil case. Therefore, before you may return a verdict which may legally be received, the verdict must be reached unanimously. In a criminal case, all 12 jurors must agree in order to arrive at its verdict. When you retire to the jury room, select one of your members to preside over your deliberations. The presiding juror's vote is entitled to no greater weight than the vote of any other juror.